topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon, Dallas-Fort Worth. Welcome to another Ask the Experts, where we bring you the top experts in the field of legal, health, financial, and home improvement. Many of you know that I am from the Dallas area, so it was real important on the expert that we chose. We had an open spot, and I've been getting your letters asking us to get a personal injury attorney, but we couldn't just find anyone. We had to find what I call the perfect attorney for personal injury, because I have about 100 friends and relatives that listen to the show every week. So it was really important, and we found an incredible personal injury attorney. And let me introduce you to attorney Robert Slim. Good afternoon, attorney.
Good afternoon, Steve. How are you?
I'm so excited. This is our first show on personal injury, and I know we're going to be talking a lot about auto accidents. And Robert, there's so many people who don't know, what do you do when you're injured in an auto accident? And that's what a show like this is going to do. And we don't want you to have to go through the internet seeing who has the nicest website. We're giving you, listen, I'm kind of dating myself, Robert. It used to be people would go, I'm going to go with whoever has the biggest yellow page ad. I don't know if you remember those days.
I remember those days.
Oh, crazy.
Yeah.
But first of all, tell everybody about yourself and your firm.
Well, my name is Robert Slim. I have a solo practice here in the Dallas-Fort Worth area. I have an office in Dallas, and I've been practicing in the Dallas area since 1995. I graduated from Baylor Law School in May of 94 and was licensed to practice law in November of 94. And my first job out of law school here in the Dallas area was in personal injury, and that's where I cut my teeth. And I worked for a firm for about 5 years or so, before I went off on my own in 1999. And so since then, I've been working on my own as a solo practitioner. And, I pride my practice on staying a solo practitioner. I like to stay small and manageable and make sure that I am dealing personally with the clients rather than, it's really frustrating. One of the things I hear from a lot of people out there is they never hear from their attorney and
Yes.
And they never get to talk to their attorney. And I hear quite the opposite from my clients. Sometimes they think I talk to them and deal with them communicate with them too often, but that's the way I like it.
So you can absolutely offer great customer service. And you're right. I've talked to people who've said, I went to a law firm because they were so big. I never even met the attorney. I went through some intake.
Yeah. And, when I say I'm a solo firm, I mean that literally. It's just me and my computer. And so I operate paperless. And so I'm able to service my clients in a very efficient manner. And I keep my caseload manageable.
And Robert, I think it's important that people know, even if you're in Fort Worth, it's okay because we got email now. And I'm sure you also talk to clients through the internet too.
Yeah,
Video Zooming.
absolutely. On my website, I have a case information form that I always encourage people to fill out and send to me, kind of give me a brief description of their case, and I read it over and I reply to them fairly promptly, probably within 30 minutes, sometimes an hour, maybe a couple hours, just depends, if I'm busy at the time. But I reply to every single one, and if further discussion is necessary, I'll call the number that you leave on there, or you can call me, or whatever it is,
Well, Robert, I'm going to tell you a little story. My son lives in Dallas. He thinks he's the ultimate salesperson. He's probably listening or watching right now. And he was in a wreck.
Yeah.
And I said, you should get a good personal injury attorney. Oh, no, I'm going to save money and handle it myself.
Yeah.
Well, know that these insurance companies have agents that are really good when it comes to negotiating, because their job is the least amount possible. He went back and forth for probably 8 months. He finally settled, and the first thing out of his mouth was, I should have hired an attorney because I left a lot of money on the table. He admitted it. Important it would have been for him to have an attorney.
Well, the way I compare it is to, fixing your own car. If you know what you're doing, then by all means do it. If you think you know what you're doing, you better think twice. Because if you start tearing into your car because you think you know what you're doing, well, you're going to cause more damage than the original problem in the first place is causing. So you may end up paying a mechanic more to fix not only the problem that you originally had, but to backtrack and fix all the problems you caused on the way in. So, what people need to understand is that when you're in a car wreck or you're in an injury claim and you are trying to get compensated from the party that is responsible, you're not involved in an insurance claim. Don't think about it as though you're, like your roof just got damaged by hail, or your home just got flooded by a broken pipe and you're dealing with the homeowners, or if you deal with your health insurance or dental insurance or life insurance. Those are your policies. Those are insurance claims. When you're dealing with a claim of liability, where you're claiming that somebody's liable and you're dealing with their insurance, you're involved in a legal claim. You may not feel like you're involved in a legal claim because you're dealing with an adjuster and an insurance company and all that stuff, but that adjuster and that insurance company is the representative of the party you are claiming is liable for your injuries. So you come in as the antagonist. You are the person claiming that their party is liable and therefore their insurance is liable to you. Well, that's not an insurance claim. That's a legal claim. And you have to picture the other insurance company and the adjuster as nothing more than the other, the liable party's legal representative, just as if they had their own, just like you're dealing with their own lawyer. So you have to picture it that way. Yeah.
Robert, are you surprised that a lot of people don't really know about their auto insurance policy?
Well, honestly, I think a lot of people are kind of, they're pretty much in touch with their auto policies. What I do find sometimes is that a lot of people, when they get into an accident, the first person they call is their insurance agent. That's a mistake, because the insurance agent, a lot of times is going to talk you out of setting up a claim with your insurance. And setting up a claim with your insurance, it may be a necessary procedure. So a lot of times the insurance agents set you down the wrong track from the very beginning, because they don't necessarily understand the claims process, because they view it as, well, the other guy's liable, his insurance company will take care of it. Well, not necessarily. That's not the way it works. And plus, you have a legal obligation to promptly notify your insurance company of any potential claims. So if you don't notify your insurance company and you suddenly need them later, well, you may run into problems, with dealing with your insurance company when you need them. So my philosophy is, let's open up all the claims. Let's get everything out on the table from the very beginning, and then we'll see what's what. That's my philosophy. So don't call your agent sells you the policy. It's no different than
Right.
if you buy a car, and it breaks down. Well, you take it to a mechanic. You don't take it back to the salesman that you bought it from. You take it to a mechanic, get it fixed. It's the same thing with your agent. Your agent sells you the policy, and then you deal with the claims on the claim side later.
Explain to people why they need an attorney if they're injured in an accident.
Well, like I said before, I mean, you're involved in a legal claim. It's you against the other guy. It's not even you against the insurance company, because the insurance company comes in as the other person's representative. Now, they are the ones, the insurance company is the one that you'll be dealing with, because they actually are the ones that'll be writing the check. So you do deal directly with them with respect to the claim. But from the legal standpoint, your claim is against the person or company that hit you or hurt you. So if you get into an accident with a guy who's driving a car and his name is John Smith, your claim is against John Smith, and his insurance company comes in and represents him. And they will represent him in a sense that they're going to do what they think is in his best interest. And if the insurance company believes that he has legal liability to you and that he has exposure to you, well, then his insurance company will step in, try to negotiate the claim with you, but not because that insurance company wants to fully and fairly compensate you. They do it because they want to protect John Smith, and they want to get your name and signature on a release. And once they do that, they close the books and it's over. Okay. So that's why you need a lawyer, because you're involved in a legal claim. And if you can't settle the claim with the insurance company, you don't get to sue the insurance company directly. Not in Texas. Some states you can, but in Texas you cannot. Your claim is against John Smith. So you have to sue John Smith. And when you're in court, you're not even allowed to mention the insurance company. You're not even allowed to talk about the insurance company. The jury will never hear about the insurance company. And if you do mention insurance, it's a mistrial. So that's why people have to understand that there are a lot of legal in and outs here when you're dealing with the insurance company and knowing what your position is. Like I said before, you're the antagonist. You're coming in from the outside in. So you have to make sure that you understand your position as, you're the opposite party to them and they're the opposite party to you. So you got to take that into account when you are viewing this claim or that type of claim.
When someone's in an automobile accident and they contact you, what kind of documents are you going to want them to bring?
Well, it depends on when they call me. See, the earlier on you call me, the better, because most, if not everything, I can get on my own. Police reports will come out later. I can get those later. Photographs are something you would take at the scene. You should have those. Information on the other driver, information on the other driver's insurance or the vehicle's insurance, information on your insurance, that kind of stuff. Notes that were taken at the scene. If a police officer came, they will give you a slip of paper with the police report number. Keep that. Those are the things. Your driver's license, maybe a picture of the other driver's driver's license. So things like that you will have accumulated while you're at the scene. Then call your lawyer, and the lawyer will take care of the rest. They will then accumulate, collect all the evidence that you collected, collect more evidence if they need to. If they need to go to the accident scene, the lawyer will go take pictures. If they need to go if you need to get pictures from the yard, where the impound yard or whatever, we can get those later. But most importantly, you want to make sure you have the names, address, telephone number, driver's license number of the other driver, and the insurance information. A lot of people just get the insurance information. No. Like I said before, your claim is against the other driver, not the insurance. The other insurance, yes, you need that. It'd be nice to have that information. You need that information. But most importantly, you need to have the information on the other driver. Because if things don't work out with the insurance company, it's the other driver you have to go after in court, and you need to know who that is.
We just got our first text of the show. This is Ben in Colleyville. He wants to know if you're hurt in an accident. He said, I do not know of a doctor that specializes in that. Do you help direct a client who's been in a wreck and's been injured on the doctor to go see?
Yes. There are doctors that are, that work with personal injury claims and attorneys on a regular basis. And most of your regular personal doctors, family doctors, things like that, they don't do that because a lot of people don't want to get caught up in the legal ramifications of an injury claim or an insurance claim and so on and so forth. But there are a network of doctors, and a vast network of doctors that work with attorneys and will work with attorneys' clients and will actually see the client without any money out of their pocket. The doctor will make arrangements with the lawyer's office to hold off on collection of their bill until after the treatment is done, until after the settlement or the recovery is obtained in the case. And so that's what a letter of protection is. They get a letter of protection. A letter of protection is a letter or a written affirmation from the attorney's office to the doctor that says, hey, in exchange for you treating the client and holding off on any collection efforts, my office will protect recovery of your bill out of any recovery we get from the case at a later point in time. And so, yes, you can make those arrangements. Once you contact a lawyer, you can make those arrangements with the lawyer through the doctors that lawyer deals with.
I think one of the best things is when a client signs up with you, just like you said, especially early, you no longer have to talk to the insurance company and have to possibly say the wrong thing. You would handle that for them.
That's why I say contact the lawyer earlier than later, because sometimes these insurance companies are very, very quick to call you before you lawyer up. That's a real term in the law. I mean, lawyer up. You hear it a lot in criminal cases where the police want to talk to the suspect before they lawyer up. Well, that's also true here. The insurance companies like to talk to the injured party or the potential claimant before they lawyer up. Because why? First and foremost, they want to get a recorded statement from that person. While they're in the confusion of the whole accident, they want to sit down with them and they want to ask them questions, record it, and get them on tape saying something that may be true then, but may not be true later. For instance, they may ask you, are you injured? Now, 24, 48 hours after the accident, you might say, I think I have some soreness, but nothing big. Well, then 3 days later, you're like, my neck and shoulders are killing me. And they come back later and try to say that you said you weren't hurt. So my recommendation is do not talk to the other insurance company when they call you. Contact an attorney. You can be polite. You don't have to be nasty about it. Just say, I appreciate you calling me. Can I have your name and the claim number and phone number? And they'll give it to you. Okay, well, I'm just not in a position to discuss it right now, but I will call you back. At that point, hang up the phone and call a lawyer. Don't give any sort of written or recorded interview. They will tell you, sometimes they'll go so far as to tell you that you have to do it. No, you do not have to do it. That is not true. You do not have to do it. And let me just clarify this. You definitely don't have to do it when you're dealing with the other person's insurance company. All right. You may have to do it if you're dealing with your own insurance company, but you don't have to do it right then. You can just tell them, let me get back with you when I'm not in a position to discuss it right now. Let me get back with you, and then start calling lawyers. And then if you have to give a recorded statement later to your own insurance company, we can deal with that later. But you're right. The earlier you get the lawyer on board, the less you have to deal with. The less you have to
Robert,
deal with.
it's amazing. A lot of people don't know how you get paid. They don't know about contingency basis. Would you explain that to them?
Yes, I will. And, I think that keeps a lot of people from even contacting me, because even though I say free consultation, they may not believe it,
Yeah. What's the catch?
Yeah. So when we say free consultation, it's a free consultation. And personal injury lawyers are not in the business of collecting money monthly from you, sending an invoice to you that you have to pay. That's not the way it works. The way we're paid is called a contingency fee agreement. And a contingency fee agreement is just a fancy way of saying we don't get paid unless you get paid. Okay. You see that a lot. And the way it works is that you'll enter into an agreement with the lawyer. It says, okay, I'll represent you and you'll agree to be my client. And the purpose of our representation is that I'll seek to recover for your damages and your injuries sustained in the lawsuit. And then when we recover, my fee will be a percentage of what we're able to recover. And typically it's 1/3 of what the gross recovery is. And it can ratchet up to 40%. That's typical of other lawyers. Some lawyers ratchet up to 45%, sometimes 50%. I don't do that. But one of the things I also have in my contract, in my contingency fee contract, is what's called a lower fee guarantee. And this is the way I was raised when I was a baby lawyer in Dallas back in the mid 90s. My mentor, said it's not good to take more money in your fee than the client nets in their pocket. And so you hear those stories about the client, the attorney taking a contingency fee of like $4,000, $5,000, $6,000, $10,000, and the client walking away with $1,000 or $2,000.
Right.
So I have in my contract a lower fee guarantee. Although I was taught to do that, I actually put it in writing in my contract. And it states in there that if we come to an agreeable settlement situation in your case, I will work it out in a way that you will net a greater amount in your net recovery than my fee, even if I have to lower my fee. So
that's unbelievable. That is amazing.
Yeah, well, because I want to make sure that, this is the client's claim. It's not my claim. I'm the client's lawyer. So it's the client's claim. And the client is the one that should come out smelling rosier than everybody else.
Robert, I don't know if you have this going on in Dallas, but here in Florida, there's several attorneys that make you think, hey, we've got this great deal. We're only going to charge you, a third. And they make it sound like no other law firm does that. Those fees are basically set by the state here in Florida. I don't know if they're set by the state in Texas, but don't let anybody fool you, though. Robert's telling you that this is what we charge on a contingency basis.
Well, like I said, in Texas, the contingency fee is not regulated or limited. There is there are some rules against charging an unconscionable fee, but that's kind of a loose term. There are some situations where a fee might be limited in like workers' comp cases. But in the typical personal injury case, car accident case, the state does not regulate the fees other than saying you can't charge an unconscionable fee. Now, whatever that is, who knows, but the contingency fees, the whole arrangement has come under a lot of scrutiny, thinking that lawyers are harvesting cases because they want to make these contingency fees. Well, and that it causes the lawyer to pursue, frivolous claims. Well, I've never seen an attorney who's willing to invest his time and money and advance his own time and money on a frivolous case. Because that's what happens. The lawyer advances their time. The lawyer advances their money for case expenses and things like that and collects that later. Okay. And they're going to wait and collect their fee later. Well, I can't imagine a lawyer is going to invest all that up front on a case that they think is frivolous. So let's just tell it like it is, But that's the way it's in Texas. It's not necessarily limited in what fees you can charge.
Robert, can a person who's partially at fault in an accident, can they still recover for any injuries at all?
Yes. In Texas, we have what's called comparative negligence. We're a comparative negligence state, which means that in certain situations, if a jury or the facts suggest that the injured party is also partially to blame in the accident, then there can be assessed a percentage of fault on that person. And if that percentage is assessed, then it is deducted from their recovery. So, for example, let's say the injured party is, the at-fault party is 80% at fault, and the injured party is 20% at fault, whether that is something that's accepted by agreement in a settlement or a jury finds that. Well, if the jury finds that you're injured to the tune of $10,000, then they'll knock the court will knock 20% off your $10,000 and you'll recover $8,000. And that's true if it's 30%, 40%, 50%. It stops there at 50%, though. If you are found to be more than 50%, in other words, 51% or more, in Texas, you are barred from recovery. Okay. Now, there are some states that'll give you they'll give you that percentage still. I mean, if you're found 60 or 70%, they'll still give you 30% of your damages. But in Texas, no, we cut it off at anything over 50%. So up to 50%, you can still recover. Anything beyond 50%, you would be barred from any recovery. It's a full defense to the claim.
You know, I told you the show goes by very fast. We've already got 2 people wanting to know your website. I'm asking everybody to write your phone number down. Now, if you're watching us, we're scrolling on the screen, but those of you who are listening on the podcast or the radio, you never know when you're going to be in an accident. And I don't want Jeff to say, who is that attorney? I forgot his name. Write this phone number down. How do they reach you, Robert?
You can call me. You can write me through my website. You can even email me directly if you want. My email address is on my website in the footer, and I'm reachable. Like I said, I'm a solo practitioner, literally speaking. It's me and my computer, and I'm paperless over here. I'm very efficient, and I keep a very manageable caseload. And I try to look at my cases from the standpoint of what would my client want from me, and that's the way I pursue everything. That's the way I pursue my cases.
You did a great job today. That's going to bring us to the end of the show today. We'll be back again with you next week with more Ask the Experts. Robert, again, thanks so much, and we'll see you next month.
It's my pleasure. Thank you, Steve.
Hold on there, Robert.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.